3. Hey everyone, Kate Miller here, coming to you on our latest Zoom session. I am joined by the brand new attorney for Miller Bowles Cushing, Ms. Mollie Ellis. Hello, Mollie.
Hi, Kate.
Hey, all right, so you're coming to us live from our studio in Charlotte. I'm in South Park. Hey, so we wanted to catch everybody up to speed because the Court of Appeals here in North Carolina came out with some new opinions last week. The first one that we're going to touch on is it's a really long opinion. It was the Kelly case, 30 pages. I think it was out of Lee County, if I'm not mistaken. And my understanding, and I will be totally honest with our viewer audience, I have not read the entire opinion from the Court of Appeals, but my understanding from what I did read is that it really centered around a child custody trial where dad wanted to introduce some evidence specifically related to the child's testimony. And I think she was a young teenager, but ultimately the trial court didn't allow it. And because of that, and I'm sure lots of other reasons, the Court of Appeals said, hey, trial court, you guys need to start over and have a whole new trial. So they reversed and remanded for a new trial. So tell us what was going on in that case, Mollie.
So ultimately, yes, the trial court's decision was reversed. They had to have a new trial. Most notably, I think, for me, was reading that the trial court didn't want the child to testify basically because they were worried about some kind of trauma or kind of an emotional process for the child in court. But what the Court of Appeals noted was that dad had exhausted kind of every area as far as keeping the child from having to undergo that trauma. They had basically asked that the court allow for them to read the notes of the therapist of the child, and mom didn't do that. And then as far as not even reading those, they were willing to obviously have the child speak with the judge in chambers, but father wasn't even allowed to do that, to listen to the child speak. So ultimately, father had exhausted all of his areas of being able to have the child not undergo this trauma. And at that point, they realized that the trial court had not even shown that there was any privilege or any reason for any clear reason why this testimony would be admissible. So they, brought that back to the trial court to then have a trial.
Yeah, and my recollection too is that it was several days worth of trial. So to think that those folks have to completely redo the whole thing is quite a bear. So a little bit messy, but so yeah, the takeaway, I guess, is if you've got evidence that you want to admit, ultimately, I think that maybe the trial court should err on the side of letting you do it, especially when it's such a major thing as it relates to the modification of custody, right? I don't know. That's my humble opinion. All right. So the second case that we've got is actually out of our home county here of Mecklenburg, and one of our very dear judges, Christy Mann. And this was an equitable distribution trial. So I'm dealing with property distribution, and this is the Cousins case. And I think that the biggest issues that the trial court was faced with that ultimately got appealed was the value of a vehicle, which there was a question as to whether it was maybe like a collector's item or something along those lines, and then distribution of a piece of property and requiring husband to refinance the property before wife's name would be removed from the deed. So what can you tell us about the Cousins case?
So as far as the Lincoln restored car, they had to look at the date of separation value of the car, and there was some argument between husband and wife as to what the net value or the market value of that car would be. And mother ultimately was able to put on enough evidence to show that the car would be a $26,070 valuation rather than like a $9,000 valuation. I think the court showed that she had used evidence from
like a valuation source.
Yeah. And they had said that basically if she could put on evidence that it was kind of kept up to grade and not at some really low value property, like they hadn't let it go, they hadn't not redone things, they had just put in a new engine, had updated some of the things on the car, so it looked pretty new. So they let her go with the way higher value than go with the much lower value as far as having the car. So.
Interesting. Yeah. I mean, heck, sounds like a good deal to me. And then the property issue where husband needed to, the trial court, Judge Mann ordered him to refinance the property before wife's name would be removed from the deed. What was the deal with that?
So husband argued that because Judge Mann had ordered that he had to have the property refinanced before he could get the deed from wife, that she had not made an absolute equitable division of property because there was some requirement placed on it. So at that point, the Court of Appeals affirmed Judge Mann and basically said that although she had kind of placed this requirement of refinancing, that was just a method of how he would be able to acquire that property, and that if he had decided to sell the property, then all of that money would go to him regardless, even if she had not refinanced it. So she had told him she had done an equitable distribution, but she had just added kind of a method of doing so, and that he would have to refinance that before, he got the deed from her signed over to him.
Makes sense to me. Cool. All right. Mollie, thank you so much for sharing all this info with us today. If anybody has any questions about all of this fun Court of Appeals stuff that we've talked about, or need any kind of help with family law stuff, we'd love to help you. Thank you so much, Mollie. We'll see you soon.
Thank you. Bye.
Bye.